So good day, everyone. We are about to discuss the legal guidelines and the law guidelines in the Data Privacy Act of 2012. So for the learning objectives, at the end of this, at the end of this lesson, the student should be able to define what the Data Privacy Act means. Second one, understand how the Data Privacy Act is used and to relate real life scenarios relevant to the Data Privacy Act. Of course, in data privacy, we are look into generally means the ability of a person to determine, to determine for themselves when, how, and to what extent personal information about them is shared with, to share with or communicated with to other people. So the Data Privacy Act of 2012, this personal information or this act can be one's name, uh, location, contact information, or the online or a real world behavior. So according to the recent data, according to the recent data, Filipinos spend an average of 10 hours and 2 minutes each day. So it is the highest hour that the Filipinos could use every day. And the Philippines are also top social media users for the fourth straight year. So the vast amount of the personal information from the Philippines, including the photos of daily activities, um, also as well as the freely circulating the web. So what has done the country to ensure the privacy data? The privacy and the data protection. So in 2012, the Philippines passed the Republic Act number 10173 or the Data Privacy Act of 2012 or what is so-called the DPA. So it is to protect the fundamental human rights rights to privacy of communication while ensuring the free flow of information to promote innovation and growth, as well as to inherent the obligation to ensure that personal information uh, and as well as the communication system in the government and in the private sector are secured and protected. So this DPA was passed in accordance with the Philippine agreements with the ASEAN vision that was year 2020. Then it is urging that, I mean, urging um, the growing business process outsourcing industry. And this law was modeled after the data protection directive with many of its terminologies and provisions similar to the privacy laws in other jurisdictions. As well as next we have what are the sensitive or what is considered sensitive personal information. So before we proceed knowing what those considered, we should also focus on what is the difference between the personal and the sensitive information. So when we talk about the personal information, it includes a broad range of information, whether it is an opinion that could identify an individual. So this personal information, it also it will vary depending on whether a person can be identified or is reasonably identified in the circumstances. It's like, for example, personal information may include as well the individual's name, signature, address, the phone number, and as well as their date of birth, as well as their employee record information, as well as the photograph, as well as the IP or the Internet Protocol. Under this also is the voice print and the facial recognition biometrics because they collect the characteristic that makes an individual's voice or face unique, as well as the location or information from a mobile device. So when we talk about the sensitive personal data, it includes the person's race, the ethnic origin, political opinion, the religious, the belief, the health, and the sexual life, offenses, and doctoral proceeding, as well as the trade union membership. So do not be confused with the personal and sensitive information, because when we talk about the personal information, um, it is an information or an opinion. It includes as well as the information or an opinion forming for part of the database, whether it is true or not, whether it is recorded in a material form or not. So when we talk about the sensitive information naman, it is the data where the data must be guarded from unauthorized access and unwarranted disclosure in order to maintain the information security of an individual or organization. So I will now give the virtual floor to the next presenter or the next discussant, Mr. Tensinko. Thank you.
Okay, thank you for that, Ms. Arpilia. Next slide, please. So now we will proceed with the National Privacy Commission. So what is this commission all about? Next slide, please. So in accordance with the Data Privacy Act, the National Privacy Commission was created in order to administer or monitor the information of each individual to ensure data protection in the country. So the main objective or the main function as to why this commission was created is as a way to ensure the data of individuals who were able to comply under this act. Next is that the National Privacy Commission coordinates with the government and private sectors of this country regarding plans on how to strengthen the protection with regards to the information of the citizens living in this country. Another function of which is to authorize a guide relating to data protection. And another function of which is to provide suggestions to the Department of Justice regarding the penalties of those citizens who were able to violate the Data Privacy Act rather. Sorry for that. And the last function of which is to ensure that any types of information relating to the individual is considered confidential. Next slide, please.
Okay, so thank you for that, Mr. Tansinko. And now let us proceed to the rights of the data subject. Next slide, please. So, what are the rights of the subject in submitting their data or for their data processing? Next slide, please. So, these are the subject or the rights of the data subject. Subject needs to be informed. So, who are the subjects? These are the people who are submitting or issuing their personal data or their data to any information processing or data processing. So data subjects have to be informed to whether personal information pertaining to him or her shall be or being or have been processed. Well, of course, before processing the subject's data, their consent must be considered first or must be asked first. So these are the things that the subject needs to know. First, the description of the personal information to be entered into the system, meaning the subject should know what are the things that they are going to submit or they are going to enter so that they know that they are submitting just enough information and what are the exact information that they are entering to the system. Second, purposes which they are being or are to be processed. Of course, as a subject, they should know. They should also know what is that for. What is the processing for? They should know the purpose of the processing your data and personal information. Third, the scope and method of personal information processing. The subjects needs to know as how will their data and personal information will be processed so that they would feel security that their personal information and data will not be leaked. Fourth, recipients of data to be disclosed. And fifth, fourth, the subject needs to know to what are the exact data and information that they're going to submit so that they would feel security with their data and information and they would know that they're sharing just enough for the processing. And the fifth, methods used for automated accesses, extent of um, authorized access. The subject should also know what the method will be used, of course. And sixth, identity and contact detail of personal information controller or representative. Seventh, period of which the information will be stored. And eighth, the existence of data subject or uh, the existence of the rights of the subject to lodge a complaint before NPC. Of course, the subject should also be aware. They must be vigilant of their rights to have access if there are any things that they seem malicious, um, to correct if they think that they have input incorrect information, and of course to complain as to whether there are informations that they have entered that are inaccurate or something that is not appropriate. um, Next slide please. Notifying the data subject. Any information supplied or declaration made to data subject the matter shall not be amended without prior notification of data subject. Well, of course, the subject information are um, what you call this, are confidential, and the subject's information should not be changed or modified without notifying the subject to any changes. So however, there are exceptions for notifying the subject. First, we have the personal information be needed pursuant to a subpoena. When you as a subject is being issued with a subpoena, that means that it is required for the data and information to be needed even without notifying the subject. Second, when the collection and processing are for obvious purposes, including when it is necessary for the performance of or in relation to a contract or service, or when necessary or desirable in the context of an employer-employee relationship between the collector and data subject. Well, of course, when the collection of the data and information are for obvious purposes, therefore the subject has already have knowledge about it, and there is no need for further notification of them about the collection of the data, since everything is obvious naman. And the third, when the information is being collected and processed as a result of illegal obligation. So meaning legal obligation. When we say legal obligation, it means that it is informed as to whether you as a subject does not agree or agree. Meaning all the informations that are needed should be submitted. And next, please. That's all for my part.
Thank you, Mr. Pagay. And another right of the data subject is the right to dispute inaccuracy. So, or the right to rectify. So you have the right to dispute and have corrected any inaccuracy or error in the data. And the personal information controller or the PIC hold about you. And the PIC should act on it immediately and accordingly unless the request is vexatious or unreasonable. And once corrected, the PIC should ensure that your access and receipt of both new and retracted information, the PIC should also furnish third parties with said information that you requested. Another right of the data subject is the right to withdraw removal. So under the law, you have the right to suspend, withdraw, or order the blocking, removal, or destruction of your personal data. And you can exercise this right upon discovery and substantial proof such as your personal data is incomplete, outdated, false, or unlawfully obtained. It is being used for purposes you did not authorize. The data is no longer necessary for the purposes for which they were collected. You decided to withdraw consent or you object to its processing and there is no overriding legal ground for its processing. And the data concerns information prejudicial to the data subject unless justified by the freedom of speech, of expression, or of the press or otherwise authorized by the court of law. And the personal information controller or the personal information processor violated your rights as a data subject. Next slide. Another right of the data subject is the right of indemnification. So you may claim compensation if you suffered damages due to inaccurate, incomplete, outdated, false, unlawful, obtained, or unauthorized use of your personal data, and considering any violation of your rights and freedom as data subject. And to exercise this right, you can write or speak to the organization which mishandled your personal information to see if you can reach an agreement and claim compensation. If you feel that your concern has not been satisfactorily addressed, you should write to the organization and inform them of your intent to take the matter to the court. Before you start court proceedings, talk to a legal advisor if you want to make a claim in the court. Another right of the data subject is the transmissibility of rights. So just like any physical property such as real estate, you can assign your rights as a data subject to your legal assignee or lawful heir. Similarly, you may assert another person's right as a data subject provided he or she authorized you as a legal assignee. And you may also invoke another person's data privacy right after his or her death if you are his or her legal guardian or legal heir. And this same principle applies to parents of minors or their legal guardians who are responsible for asserting their rights on their behalf. And this right, however, is not applicable in case the process personal data being contested are used only for scientific and statistical research. Next slide. So the last right of the data subject is the right of data portability. So this right assures you that you remain in full control of your data. So data portability allows you to obtain and electronically move, copy, or transfer your data in a secure manner for further use. And it enables the free flow of your personal information across the internet and organization according to your preference. And this is important, especially now that several organizations and services can reuse the same data. And data portability allows you to manage your personal data in your private device and to transmit your data from one personal information to another as such, it promotes competition that foster better services for the public. And that's it for the rights of data subjects. Thank you.
All right. All right. So now to strengthen the confidentiality of someone's privacy or someone's information or personal information rather, I'll be discussing the IRR or implementing rules and regulations of the Data Privacy Act of 2012, also known as RA 10173. So when we speak about RA 10173, this is actually a law that requires anyone processing the personal information and protect that personal information. This particular law was actually promulgated in 2012 and already existed, but the implementing rules and regulations took effect only in 2017. So what is this law all about? The law actually balances the free flow of information and the protection of the personal information data subjects rather. There are three actually fundamental principles the processing and governing the processing of personal data. So first we have, before I forget, when we speak about processing concerning this particular app, this involves collection, recording, use, erasing, modification, and even storing or retrieval of information that is actually considered as processing of information in Data Privacy Act of 2012. And when we speak about personal data, it is basically any type of information wherein the identity of the individual can be reasonably determined. So as what I was saying, I will be discussing the IRR of this particular law, particularly Section 17, 18, 19, and 20. So Section 17 stated that general data privacy principles, the processing of personal data shall be allowed subject to compliance with the requirements of the Act and the laws allowing disclosure of information to the public and adherence to the principles of transparency, legitimate purpose, and proportionality. So when we speak about first, let's talk about first is the transparency. When we speak about transparency here, the data subjects must be aware of the nature, purpose, and extent of the processing of or his personal data, of someone's personal data, including the risk and the safeguards involved, the identity of personal information controller, his or her rights as the data subject, and how this can be exercised. Any information and communication relating to the processing of personal information or personal data should be easy to access and understand using clear and plain language. So it is highly required to use clear and plain language to promote transparency. In short, this requires notices to be given to the data subjects. To the data subjects, the data subjects must be informed first that the data that will be gathering or getting from them is actually be using in this particular thing now. So it's limited. So it should be specific. Next is the legitimate purpose. When we speak about the legitimate purpose, the processing of information shall be compatible with the declared and specified purpose, which must not contrary to the law, morals, and public policy. So, legitimate purpose does not only it should not only specific, but most importantly, it should also not be contrary to the existing laws and public policy. In short, the processing should have legitimate purpose, meaning it should be lawful, or the purpose of the processing should not violate any existing laws. The last will be proportionality. So when we speak about proportionality of information shall be adequate, relevant, suitable, necessary, and not excessive in relation to the declared and specific purpose. Personal data shall be processed only if the purpose of the processing could not reasonably be fulfilled in other means. In short, the legitimate purpose must be consummate or parallel to the volume of the nature of the data that is being collected and processed. Now let's talk about the section 19, which states that general principles in collection, processing, and retention. The processing of personal data shall adhere to the following general principles in the collection, processing, and retention of personal data. I'm sorry, next slides, please. Okay, now let's talk about the section 19. So first, collection must be for a declared, specific, and legitimate purpose. So particularly consent is required prior to the collection and processing of personal data. And when the consent is given, it must be time bound in relation to the declared, specified, and legitimate purpose. So that again, consent is also can be withdrawn. Yes, it can be withdrawn by the subject if requested. Next is the data subject must be provided specific information regarding to the purpose and extent of the processing. And the purpose should be determined and declared before. So, diba, when we are conducting our research to the respondents, when we are asking or getting information from our respondents, we are actually providing disclaimer, the purpose of the information, concerning the purpose of the information that we will be getting from them, and how long are we going to use those particular information. And also for example, in the classroom setting, when our teacher is conducting or we are conducting a synchronous class, when our teacher is actually recording our session, she or he will request first for our approval or permission to record our discussion because it will be against this in this particular act. Next is personal data shall be processed fairly and lawfully. So processing shall uphold the rights of the data subject, including the right to refuse, to withdraw consent, or object. And lastly, Section 20. Section 20 stated that general principles for data sharing. So further processing of personal data collected from party other than the data subject shall allowed under any of the following conditions. So first, we have data sharing shall be allowed when it's expressly authorized by law or by the owner of that particular information. Next is data sharing shall be allowed in the private sector if the data subject consents to data sharing, the following conditions are complied. And lastly, the data subject shall be provided with the identity of the personal information controllers or personal information processor will be given access to the personal data. And existence of the rights of the data subject, including the right of the access and correction to the right to the and right to object. So this is actually was discussed a while ago. So that's it for the section 17, 18, 19, and 20 for the implementing rules and regulation of the Data Privacy Act of 2012 or the RA 10173.
Okay, next slide, please. So what happens if the individual has violated the Data Privacy Act? Next slide, please. So now we will be talking about the penalties of the Data Privacy Act. Okay, next slide, please. So Chapter 8 of Section 25 of the Data Privacy Act tells the penalties with regards to unauthorized processing of personal information and sensitive personal information So the violator will be penalized by imprisonment ranging from 1 to 3 years and a fine of 500,000 pesos to 2 million pesos. Next slide, please. Now we will be relating example of a real life case that is related to the Data Privacy Act, which is called the illegal activity of data breaching. So what is data breaching? Next slide, please. So data breaching is a type of incident wherein the information has been stolen from the system without the knowledge or consent of the owner. So the act of data breaching will have a negative effect to the companies, may it be small or big. An example of data breaching may be in the form of stolen information consisting of the following. It could be a credit card number, customer data, and trade secrets. Okay, I hope you understand. Next slide, please. So an example of data breaching is when the Office of the Solicitor General of the Philippines suffered a case of data breaching, wherein 350,000 sensitive information became exposed and accessible to the public for at least 2 months during May 3 to 2021, according to the London-based security firm. Okay, next slide, please. And that is the end of our recorded session. I hope you were able to understand something from our discussion. Thank you and good day.